being read and spoken about. But the things to be cheered about for the last year was that we all have started connecting ourselves through a virtual platform for having knowledge amongst us from speakers who could share their knowledge on different perspectives of law. And then that endeavor, we requested Mr. Vishwanath Angadi, a former principal city and district judge from Bangalore. And topic for today's discussion is also quite fascinating. That is concept of legal rights, characteristics of a legal rights, and types of legal rights. Mr. Vishwanath has always been quite close to the academics. He has taken various classes in the Judicial Academy and at various different places. And that aspect triggered within us that we should request him to give a topic which, according to us, is quite insightful. And he was kind enough, though we all know that on first, everyone is busy celebrating the year with new hopes, new aspirations. But as they say that if you have too much closeness towards teaching and passion to share the knowledge, that doesn't stop you even from celebrating a new year, because one feels that sharing is the best way to move forward in life. And we are grateful to Mr. Vishwanath Angadi, who has also acceded to our request, and he will be taking a session tomorrow also, but tomorrow at 5 p.m. And thank you on behalf of all those participants who are watching us live on the Facebook as well as on YouTube and on this platform, to sir, and wishing you Happy New Year on behalf of all those participants who are watching us live. Over to you, sir.
Thank you, sir. Thank you very much for your kind words. At the very outset, I wish all the advocates, law college students, and all the viewers online a very happy and prosperous New Year. Let this year bring in good health to all of us, and that we'll be back to our regular work physically. And now that we are set for online work, I'm sure that we have to mix both hybrid version of online as also what is called as physical attending or physical hearing. The topic given for study in this webinar, as told by the organizer, is fascinating. There is a branch of the subject called as jurisprudence. As we all know, while studying law, this paper was said to be a tough paper. And if we could just get the minimum pass marks, we were very happy. And now the chapter chosen is concept of legal rights. What is called as legal rights? What about its various dimensions? In what ways we can use the phrase legal rights in various connotations? I'm very sure that in law courts, they will not ask us to define what is called as a right, what is called as a legal right. It is more a question of academic interest for the jurist, also for the advocates, and for those persons who are law researchers. Advocates, if they're empowered properly on the aspect of this chapter, legal rights, I'm very sure that they can fine-tune their pleadings, their draftings, by use of appropriate legal words at the appropriate place, so that the reader or the judge or the counterpart will know that we are surely refined in terms of legal background, legal backing. With this brief prelude, I will start quickly what is my important aspect of the webinar. I'll give quickly the brief points which I am going to cover in this chapter, concept of legal rights. We cannot define the word legal right directly. We must define previous to it the backdrop words, meaning of the word wrong, meaning of the word duty, what is called as a right. Then comes the aspect of meaning of legal right. Wrongs are of two types, moral wrongs, legal wrongs. Duty are also of two types. What is duty and what is obligations? We'll discuss. And we'll discuss also five important features of a legal right. The first one is person of inherence. Number two is person of incidence. Number three, content of a right. Number four, subject matter of a right. Fifthly, title of right. Then comes the threefold relations when there exists interplay of a legal right. Then we'll discuss of four types of legal rights in its wider sense. Rights in strict sense, liberty, power, and immunity. Then nextly, the last point is kinds of legal rights. There we have got as many as 18 different types of legal rights. The first set is perfect right, imperfect right. Number two, positive and negative right. Number three, rights in rem, rights in personam. Number four, corporeal rights, incorporeal rights. Number five, principal right and right which is called as rights which are called as accessory rights. Sixth is primary rights and sanctioning rights. Seventh is rights in re propria and rights in re aliena. Eighth is legal right, right in equity. Lastly, vested right and contingent right. This is the brief point which I will cover in 1 hour and 10 minutes, or as the speaker decides. If they want to ask questions, they may put it across to me at the end of the session. First, we'll define the word wrong. What is called as a wrong? Wrong is defined as simply a wrong act or a wrongful act, an act which is contrary to rules of right and justice. Wrong is defined as simply a wrong act which is contrary to rule of right and justice. That is called as a wrong. Wrongs are of two types, moral or natural wrongs. Number two, legal wrong. In case of moral wrong, that is contrary to rules of natural justice, rules of morality. In case of a legal wrong or wrong, that's an act which is contrary to rules of legal justice and is a violation of law. The next point is what is called as a duty. We speak of right and duty. What is called as a duty? Duty is an act which one ought to do. Duty is an act which one ought to do. That is called as duty. Duty of teacher to take classes, duty of the bus conductor to issue tickets to a passenger paying fare. Duty is an act which one ought to do. An act, the opposite of which is or would be a wrong. I pay to the conductor the bus fare. The conductor does not give to me the ticket. Then we speak of wrong by the bus conductor in not giving ticket to me, in spite of I making payment of the fare of the journey. The next point is whether duty and obligations are the same thing or are they different? Duty differ from obligations. Obligation is a thing or an act on my own choosing. I choose it to do a thing that is called as obligation. Duty means an act which one ought to do, one should do, that is the duty. So obligation, as you all know, obligation I take upon myself. I tell to my friend, I will give you a loan of rupees 1 lakh if required. My friend says he wants loan. I give him the amount of loan of 1 lakh. So in this case, there is no duty on my part to give a loan to my friend. I, on my own choosing, make a promise that is called as obligation. So wrong is different, duty is different, so also obligation. Duties are also just like wrongs of two types, that is moral duty and legal duty. In case of moral duty, as you all know, duty of the son not to smoke in front of his father, duty of son to obey the command of the parents, that is moral duty. Legal duty means duty which the law states we cannot sell milk which is infected with germs. We got the Acts, Food Safety Standards Act, or else a vendor cannot sell a product which is borrowed by time. That data expiry is over, he cannot sell it. So that is called as a legal duty, a duty which one ought to do. And for breach of legal duty, there is sanction to enforce the said breach. The next point is what is called as right. I discussed wrong, I discussed duty, I discussed obligation. Now the point is what is called as right. Rights are defined as interest protected by rules of right, that is, by moral and legal right. Rights are defined as interest protected by rules of right, that is, by moral and legal rights. Now, the question is we say rights as interest. What is called as interest? Or define the word interest. Interest are things which are to a man's advantage. Man has interest in his freedom or his reputation. We say that X has interest in his reputation. Nobody can say X is so and so. Nobody can defame X. So we speak of the word interest as a thing which is to a man's advantage. They concern interest of a man in his freedom or his reputation. That is the aspect of right and the word interest. Rights are of two types, moral rights or legal rights. In case of moral rights, interest protected by a rule of morality. Parents expect that our children should not misbehave. That is the moral right of the parents. So they are based on rules of morals or rules of morality. What is called as a legal right? An interest which the law protects, that is called as a legal right. An interest protected by a rule of law is called as a legal right. Now the question is whether a bear, whether a four-footed animal or whether beast have got legal rights or not. The question is whether cows or the four-footed animals, they got legal rights or not? Are they fit subjects of legal rights or not? So here the question is, beast, as you all know, are said to be things, they are said to be objects, they are said to be not natural persons or persons in law, and that it is said that interest, it is said that interest of beast is protected by what's called as Prevention of Cruelty to Animals Act, which states that nobody can ill-treat a beast or an animal of a given type. But they are not by themselves possessed of legal rights, but state takes care of the aspect of interest of the beast or four-footed animals as the case may be. So with this, the next important point is every right and every duty involves a vinculum juris. Vinculum juris means bond of legal obligation by which two or more persons are bound together. Every right, every duty involves a bond or connection between two or more persons, and that two or more persons simultaneously undertake to do their respective promises. So every right and duty involves bond of legal obligations by which two or more persons are bound together. So a banker promises to lend to a borrower the amount of loan, and the borrower agrees to repay the amount of loan with interest. That is called as every right and duty have with it what is called as a bond, or that's called as in legal phraseology, vinculum juris, bond of legal obligations, by which two or more persons are bound together. Then the next point is what's called as duties to public. Duties which we owe to public, there is no collective or co-relative right. There is no co-relative right, and the duty to refrain from committing a public nuisance is called as duty which is on the public, and here we speak of duties to public, for that there is no correlative right. In fact, state is custodian of law, that's correct, but in strict sense, we say that duty to refrain from committing a public nuisance, for that, there is no correlative right. The next important point is what about the five important features of a legal right. I told you the five features of a legal right just in the beginning. The first important feature is namely every legal right, every right to be called as a legal right must test all those five features. There should be there should be the following five features. The first point is a legal right. It must be, it is vested in a person. So we speak of owner of a right. So for every legal right, there is a person who owns it. He is called as owner of right. The subject of it, the person entitled, he is called as person of inherence. The person who gets right on account of a transaction, he is called as person of inherence. And every legal right is vested in a person, maybe natural or legal person. He is called as owner of right. The subject of it is the person entitled or person of inheritance. So the first point is every legal right is owned by some person. Number two is it avails against a person upon whom lies the correlative duty. It avails against a person upon whom lies the correlative duty. He is called as person of incidence, person who is bound, or person subject to duty. So he is called as person of incidence, person who is bound, and first point is person who inherits, person who has the right, who is owner of right. The second point is person of incidence, person bound to comply with terms of the transaction. The third point is content of a right. It obliges the person bound to an act or omission. That is the third important feature of a legal right. We call it as content of right. So the third feature is content of right. It obliges the person bound to an act or omission in favor of person entitled. The fourth feature is namely object or subject matter of a right. The act or omission relates to something or some property or some transaction. That is called as subject matter of a right. The fifth important point is namely every legal right has a title. Every legal right has a title. Title means certain acts or events which take place on account of a transaction and they become vested in the hands of the owner. So every legal right has a title, certain acts or events by reason of which the right has become vested in the owner. So these are the five important features of a legal right. And to explain all these five features in one example, which is for benefit of law college students, I'll give an example. A buys a piece of land from B. A is buyer, B is the vendor. So this small transaction involves the aspect of five features of a legal right. So A buys a piece of land from B, A is buyer, B is vendor, and here A is the owner of legal right acquired. Buyer gets the right of ownership to the property which has purchased. A is called as subject or owner of right acquired. And here, content of right is non-interference with A's exclusive use of land upon the sale deed which the vendor B executes in favor of the buyer A. That's called as content of right. Non-interference with A's exclusive use of land. And number two is public in general have got a corresponding duty not to interfere with portion of land of the owner. A is owner of land. Land is here called as object or subject matter of right. Land here is called as object or the subject matter of right. That is the fourth feature. Title of right here is conveyance or sale deed which the vendor executes in favor of the purchaser A. So title of right is the conveyance or deed of conveyance, sale deed. So this example of A buying land from B contains all these 5 features of a legal right. So with this example, the next important point which I will touch quickly is namely every right has a threefold relations. Every right has got threefold relations. First one is it is a right against some persons or some person. Every right is against some person or some persons. Number two, it is a right to some act or omission of such person or persons. The third fold is it is a right over or to some to which that act or omission relates. So we have got for every right threefold relations. Number one, it is against some persons. Number two, it is right to some act or omission of such persons. Thirdly, it is a right over or to something to which that act or omission relates. So with this, the next important point is what is called as the word legal rights. So a right serves to protect an interest and object of the right is the thing in which the owner has this interest. So it is said that a right serves to protect an interest. An object of the right is the thing in which the owner has this interest. Now the question is rights in its broad sense of the term. The word rights in its four, the, the phrase legal rights in its wide sense of the term has got the following 4 important connotations. Rights in strict sense. Number 2, liberty. Number 3, powers. Number 4 is immunities. Rights are used in other context also. What is called as rights in strict sense, what is called as liberty, what is called as power, what is called as immunity. They are called as co-relative terms. So I will tell now quickly what is called as liberty. Liberty or license or privilege are the benefits which I derive from absence of legal duty imposed upon myself. When I speak of liberty in myself, liberty or license or privilege, it means that there is benefit which I derive from the absence of a legal duty. So liberty and legal duty, they will not go together. They are poles apart. Liberty and this particular duty, they will not go together. I have liberty to do as I please with my own. I am owner of car. I got liberty to do whatever with my car or with my particular thing. But I have no right to use my car and dash to a pedestrian crossing road, not in the zebra crossing strip. Though I am owner of a vehicle, owner of a thing or a product, I do not have the legal, I have no legal right to invade upon rights of somebody else. I have liberty to do as I please with my own. That's correct. I have no right, or I have no liberty to interfere with what is another person's liberty or right. I have a right to express opinion on public matters. Say, if I got the important fundamental right, freedom of speech, expression, I can express, but I have no right to publish a defamatory article in a newspaper. So I have no right to publish a defamatory article in a public, in a newspaper. That is the aspect of the word liberty. The third point, the next important aspect is what is called as no right. No right means no right is a manufactured word indicating absence of right against some other person in some other particular respect. The next point is power and liability. Power and liability will not go together. They are poles apart. As I told, the word liberty and no right cannot go together. So also powers and liabilities will not go together. They are poles apart. What is called as power? What is called as liberty? So powers which a judge is empowered under Act of Parliament. Powers of judge under CRPC to punish the accused. That is as per statute. And here, power which a judge exercises, the said judge has no liability. So power and liability, they will not go together. So in case of power, there is no corresponding duty. That is the aspect of powers and liability. Power of sale vested in a mortgagee for default on the part of the mortgager to repay the amount of mortgage money. So the mortgagee can bring for sale the mortgage property in case of non-payment of the amount of dues. That is power of sale vested in a mortgagee. The oral power of a judge in a given case, and for that there is no corresponding duty. So that is as called as power and liability. Power is not the same thing as what is called as right. Power is not the same thing as right. Power is defined as ability conferred upon person by the law to alter by his own will, directed to that end the legal relations either of himself or of other persons. Power is defined as ability conferred upon a person under law, by law, to alter by his rights, duties, liabilities, or other legal relations, either of himself or of other persons. So with this, there are two types of powers: public power and private power. Public power means vested in a public authority. Private means vested in persons in their capacity. Father has the power on his son, and the public means power of power of a judge, power of a judge of a court in a given criminal case. And with this, the next point is what is called as liability. In case of liability, that is the position of one whose legal rights may be altered by the existence of power. So liability of tenant, of re-entry by landlord once the term of lease is over. The lease deed is for 1 year, term is over, the landlord can seek from tenant rate of re-entry. He can go to court for a suit for eviction, that is liability of tenant of re-entry by the landlord once the term of lease is over. The next point is what is called as immunity and disability. Immunity is not the same thing as a right. In case of immunity, it is an exemption from having a given legal relation changed by another. Immunity is an exemption from having a given legal relation changed by another. So, immunity, in short, means what's called as no liability. Immunity, in short, means no liability. So that is what's called as immunity. So where there is immunity, then we say that there is no liability. We speak of immunity of the diplomats, ambassadors. So there is no question of liability. So there is no liability of a person having immunity. The next point is what's called as disability. What is called as disability? That is inability or no power. In case of disability, there is inability or there is no power. Disability is simply absence of power. Disability is simply absence of power. So a person who is not agent of somebody else cannot do any work on behalf of the principal. Principal must empower the agent to do a given thing. So in this case, disability is simply absence of power. Nemo dat do it non habet. That is the Latin words. I think the next point is disability on the part of persons in general to transfer property that they do not themselves own. Owner is X. A third party cannot sell the land owned by X or A, the landowner. So, owner of land has the right to sell. A third party cannot sell that land of somebody else. So, disability is on the part of public in general to transfer property that they do not themselves own. That is the aspect of disability. The next point is what's called as the next important aspect of our study is the aspect of 9 important sets of legal rights. The first important set is what is called as perfect right. Number 2 is what is called as imperfect right. So, what is called as perfect right? What is called as imperfect right? We'll discuss now. So, legal rights can be used in 18 different ways. The first set is what is called as perfect right and imperfect right. What is called as a perfect right? What is called as an imperfect right? In case of a perfect right, that corresponds to a perfect duty. A perfect duty which is enforceable at law. Perfect duty enforceable at law is what's called as a perfect right. Perfect right corresponds to a perfect duty, and that particular right can be enforced in a court of law or at law. The legal right can be enforced. That's called as a perfect right. In case of imperfect right, we got a right, no doubt, but that right is not enforceable. But for law of limitation, there cannot be recovery of amount of a time barred claim. Suit or promote for recovery, what file the suit within 3 years from the date of the DP note or pronote. Any suit filed after 3 years, we call it as a time barred debt. That is called as imperfect right. I got right, but that right cannot be executed in the court of law because of law of limitation. So that's called as imperfect right. Imperfect right means, example is time bar debt. Perfect right, the example is a claim which is within the period of limitation and for which there are lawful documents to recover the amount of dues. The next point is perfect right. I mean, positive right and what is called as negative right. What is called as a positive right? What is called as a negative right? Positive right corresponds to a positive duty. Positive right corresponds to a positive duty and is a right that he on whom the duty lies shall do some positive act on behalf of person entitled. So positive right corresponds to a positive duty and that is a right and is a right that he on whom the duty lies shall do some act or thing on behalf of the person entitled. The example which I can give is I have a right against everyone not to be pushed into the water. I am just seeing the level of water in a swimming pool, in a hotel, in a five-star hotel. As you all know, in a five-star hotel, the swimming pools are maintained extremely fine, and that I'm just watching how the swimming pool is built, and I'm just feeling the way it is maintained by the hotel owner. So I have a right against everyone, every bystanders, just near the place where I'm standing, watching the swimming pool. So I have a right against everyone not to be pushed into the water. Nobody can push me into the water in the swimming pool when I'm watching it. That is called as positive right. So a positive right corresponds to a positive duty on third parties who cannot push me into the water of the swimming pool, which I am seeing at a given point of time. As regards negative right, that corresponds to a negative duty. So in case of a negative right, that corresponds to a negative duty and is a right that the person bound shall refrain from some act which would operate to the prejudice of the person entitled. So in case of a negative right, we have got element of negative duty and is a right that the person bound shall refrain from some act which would operate to the prejudice of the person entitled. So the same example of myself watching the water in a swimming pool. So I have no right to push somebody else into water. That's called as my negative right. I have no right to push somebody else who are seeing at a particular place, or they are seeing a swimming pool, as the case may be, which I quoted of the aspect of positive right. So that is the second branch of legal rights, rights being positive and rights which are called as negative rights. With that, the third set of legal rights is which are we use in common parlance in our pleadings, rights in rem and rights in personam. Rights in rem and rights in personam. Rights in rem is also called as real right also. And rights in personam is also called by some authors as personal rights also. What is called as rights in rem? What is called as rights in personam? The very word rem or the word personam indicates the meanings. Rem means on all the people at the word at large. And the word personam means against a fixed person. So rights in rem correspond to a duty imposed against persons in general. Entire public have got the duty not to interfere in my right with regard to a property, maybe a land or a building, as the case may be. So rights in rem correspond to a duty imposed against persons in general, and that is available by me against the entire world at large. My right to peaceful occupation of land or building, that's called as rights in rem. The next point is rights in personam. So they correspond to a duty imposed upon a fixed set of person or persons, and I can avail that particular rights in personam against that particular person only. So that is what's called as right in personam. Here the example is, I am owner of a land. I have given on lease the premises to a tenant. And as per the lease deed, the rent amount is, say, rupees, say, a fixed amount payable on every month or payable every year. So I got a lease deed. L is landlord, T is tenant, and lease is for a fixed number of years. Rent is so and so per month or per annum. So right of landlord L to recover the amount of rent from T, the tenant, is a case of application of rights in personam. So the landlord can recover rent only from tenant, that is a fixed person or individual, and not against somebody else. As long as T is, still living, legal heirs of T cannot be sued by the landlord, or somebody else cannot be sued. That's called as rights in personam. Rights of a person against a fixed person or individual or individuals. The fourth set is what is called as proprietary rights and personal rights. That is the fourth set of legal rights. So the word proprietary is also called as corporeal by some jurists. So proprietary rights or corporeal rights and incorporeal rights or personal rights. So the point is, what is called as corporeal rights? What is called as incorporeal rights? So in case of a corporeal right, that is aggregate or sum total of a man's proprietary rights, which constitutes his estate, his property, money, or money's worth. So we speak of here estate or property which we can compute in terms of money. So property in a given valuation, estate, its value.
It's 5
And
o'clock.
I may want some shares. That's also called as what's called as corporeal rights. So aggregate of a man's rights regarding his properties, his estate, his assets, or shares of a company, and they're all worth in money. They are money's worth, or a man's wealth can be called as corporeal rights. I can compute the value of shares. I can compute value of the buildings. I can compute value of a car. That's called as corporeal right. I can quantify its value. What is called as incorporeal right? What is called as incorporeal right? In case of incorporeal right, they concern a man's personal rights, a man's status. So, in case of incorporeal rights, the sum total of a man's personal rights, namely concerning his status or his personal condition, that is the sphere of incorporeal rights. They concern status. They concern what's called as his personal rights. So, rights, right of husband on the wife, right of wife on the husband, right of father on the son, right of mother on daughter, as the case may be. So, in case of incorporeal rights, we speak of a man's rights with regard to his status or personal condition. So, as a husband, as a father, as a mother, as a daughter, or as a free man, and they are called as not worth money or money's worth. We cannot compute the value of a person, value of a wife, value of a husband, as the case may be. And here, we cannot compute in terms of money the value of those important rights which are called as incorporeal rights. They are not money's worth, they are rights. In fact, they are called as incorporeal rights. That is the fourth set of legal rights. The fifth set is rights in re propria and rights in re aliena. That is the fifth set of legal rights, rights in re propria and rights in re aliena. Rights in re propria is called technically as jus in re propria, and rights in re aliena is called technically as jus in re aliena. And rights in re aliena means encumbrance. We speak of encumbrance of a bank on the landed property owned by X, the borrower. So the banker advances loan to the borrower on mortgage of the property taken as security by the banker. So rights in re aliena means it's a case of encumbrance which limits or derogates from some general right of some other person who is owner of the right, owner of the building. So in case of rights in re aliena, that is a case of encumbrance which limits or derogates from some other general right of owner of right, namely owner of building, that's called as rights in re aliena. So rights in re propria means right of landowner is limited by use of land by the tenant as long as the period of rent, period of lease is still not over. Landlord has got right minus right of tenant to use the land until the term of lease is over. Right of landowner limited to use of land by tenant, that is called as rights in re propria. And here, in case of encumbrance we have got four types of encumbrances. Firstly, what is called as lease of property. So in case of lease, there is encumbrance of property. Here, the landlord or lessor gives to the lessee the portion of land that's called as lease. So there is rights in the aliena. The landlord gives to the tenant the particular building or land, and that's called as lease of property. That is called as encumbrance of property. That is a branch of rights in re aliena. The second type of encumbrance is servitudes. What is called as servitude? Servitudes are rights to limited use of land, unaccompanied either by ownership or handing over of possession. In case of servitude, there's a case of right to limited use of land, unaccompanied either by transfer of ownership or handing over of possession. I am owner of property. I don't give possession to somebody else. I am owner of property. I don't part with my ownership. But still, I permit somebody to use it. So the example is right of way. Right of way given by me to my neighbor to use the pathway to go to his land. So the land of my neighbor is at the back of my land and he has no right of entry. I say, you use this 5 feet pathway from my land to enter your land. That is called as servitude. Right to limited use of land unaccompanied by transfer of ownership or transfer of portion of land. Example is right of way, right to passage of light as the case may be. That's called as the second type of encumbrance. The third type is security. As you all know, banker takes a land as security for loan. There is encumbrance of land by the borrower to the banker by means of mortgage deed or hypothecation of the vehicle in case of a car loan. Fourth is trust. So as you all know, trust is a case of duplicate ownership. Two persons own the same property at the same point of time. In case of security, as you all know, an encumbrance vested in a creditor or a lender or a banker or property of a debtor or a borrower for recovery of the amount of loan. That is called as security. I mean, encumbrance vested in a creditor over property of debtor. That is the aspect of security. In case of trust, it's a case of duplicate ownership of the property. Ownership of property is limited by an equitable obligation to deal with it for the benefit of someone else. Owner gives property to the trust to be used by the beneficiary or somebody else. That is the aspect of what is called as, trust. So in case of trust, that is an encumbrance. There is an encumbrance in which ownership of property is limited by an obligation to deal with it for the benefit of somebody else. So beneficiary, they are entitled to the benefit of the trust property, and we speak of a case where there is trust. So it's a case of duplicate ownership. That is the fourth set of encumbrance. So with this, the sixth heading is principal right and accessory right. What is called as principal right and what is called as accessory right. So that is reverse of what's called as the previous one, reverse of servient and dominant rights. So what is told by me previously is the reverse. So in case of principal and accessory rights, that is the reverse of servient and dominant rights. A security is accessory to the rights secured. I give to the banker the vehicle by means of execution of deed of hypothecation of the vehicle. So a security is accessory to the rights secured. A servitude is accessory to the ownership of land or vehicle for whose benefit that exist. So rent and covenants of a lease are said to be accessory to the landlord's ownership of the property. Rent and covenants of a lease are accessory to the landlord's ownership of the property. That is the aspect of principal and accessory rights. The seventh important subtype of the legal rights is the seventh subtype is what is called technically as primary rights and sanctioning rights. What is called as primary rights? What is called as sanctioning rights? Primary rights have some source other than wrongs. In case of primary rights, they have got some source other than wrongs. Whereas in case of sanctioning rights originates from some wrong, namely from the violation of some other person's right. So in case of a primary right, they have got some source other than wrongs. In case of sanctioning rights, I mean, there is that they originate from some wrongs, namely from the violation of another person's rights. And primary rights are either rights in rem or rights in personam. Rights in rem means my right not to be assaulted, and if my rights are assaulted or inflicted, I can seek damages for that violation of my legal rights. Rights in rem may my right to claim damages for violation of that right, and I have the right not to be assaulted. If I'm assaulted, I can seek for damages. Rights in personam in the context of primary rights is my right that you perform contract with me. In case of suits for performance of a contract of sale of a land, I can pay the court to direct the defendant vendor specifically to perform the contract, or pay to me damages for breach of the contract. That is right in personam in the context of what's called as my primary right. With that, the eighth important set of legal rights is namely what is called as legal right and what is called as rights in equity. That's called as equitable right. So what is called as legal right? What is called as right in equity? That's called as equitable right. So in case of legal rights, those rights, those rights which the common law courts recognize. Common law courts in England, they recognize those rights. They are called as legal rights. At common law, those rights are recognized, and there is force in the common law. The source for legal rights of the eighth type are namely from the common law, and common law courts in England recognize what's called as the legal right. And here, legal mortgage of land as per the TP Act, Transfer of Property Act, it must be created by a deed. So, legal mortgage of land must be created by a deed. That is the aspect of legal right in the context of rights which the common law courts recognize. Then what is called as rights in equity. That's called as equitable rights. So the rights which courts of chancery they recognize, they're called as rights in equity or equitable rights. So we have borrowed this concept in our TP Act, Transfer Property Act, Section 58 of the TP Act. As per 58 of the TP Act, there can be mortgage by deposit of title deeds of a particular person, owner of the property, for loan availed from a banker by a simple deposit of title deeds without registration of a document. No need to execute mortgage deed. Simple letter endorsing the sale deeds or deeds of title of the property given by the mortgager to the mortgagee will create transfer of property under the TP Act, what's called as mortgage by means of equitable mortgage by means of deposit of title deeds. So there's no need that mortgage deed should be in writing, as in case of a legal mortgage, in case of common law courts. So 58 of the TP Act speaks of a type of mortgage that's called as mortgage by deposit of title deeds. Here, there's no need to execute a regular mortgage deed by the mortgager or borrower in favor of the mortgagee or the particular lender or creditor. The last heading is vested right and contingent right. They are the branch of Indian Contract Act of 1872. Section 31 of the Contract Act speaks of vested right, and it speaks of what's called as rights which are contingent. In case of vested right, right already vest in a person by means of some act or thing. So X gives loan to Y. X is the lender, Y is the borrower. The period of loan is 3 years, and we have got a schedule of repayment. And once the repayment schedule is not adhered to by the borrower, the banker can approach the court by a recovery of the amount of dues. So that's called as a right which is vested in the banker. So in case of vested right, there is already right which is perfect. It can be executed. And in case of rights being contingent, right of unborn person not still born has no right to the property. Rights of unborn persons or rights as per will, upon death of so and so, you get the property. Or else, so there are the aspects of rights which are called as contingent rights. So the ninth heading is vested right, and what is called as rights which are called as contingent, and the section is what is called as 31 of the Indian Contract Act. So I have summarized in brief the chapter of concept of legal rights, and to round up the webinar, I spoke about what is called as wrong, types of wrongs, moral wrongs, legal wrongs, duty, legal duty, moral duty, duty versus obligations, right, moral or legal right, right and interest, how they differ. I spoke of 5 important features of a legal right. First one was person of inherence. Number 2, person of incidence. Number 3, what's called as content of right. Number 4 is subject matter of right. Fifthly, what's called as title of right. I spoke of 3-fold relations in case of a right being in existence, right against some persons. Second fold is right to some act or omission. Third fold is what's called as right over or to something to which that act or omission relates. I spoke of 4 types of legal rights. Then it's a wider sense of the term, rights in strict sense versus rights versus duty. Number 2, liberty versus no right, power versus liability. Then fourth is immunity versus disability. Then I spoke of the types of 18 legal rights: perfect right, imperfect right, positive right, negative right, rights in rem, rights in personam, corporeal rights, incorporeal rights, rights in propria, rights in the aliena, principal rights, accessory rights, primary rights, secondary rights, equitable rights, and legal rights, and vested rights and contingent right. So, if you have got any doubts on what is being, and I could know a question being asked by one of the viewers there: distinction between legal rights and fundamental rights. That is a very good question. As you all know, the Indian Constitution guarantees to the citizens what's called as fundamental rights. Article 14, Article 16, Article 21, Article 23. So the right to liberty, right to profess, practice any profession, right of freedom of speech and expression, they are said to be fundamental rights. Even during emergency also, those rights cannot be suspended. Those rights are inborn by virtue of the Constitution of India. It's a document which is created in 1950. We have those fundamental rights. In case of legal rights, those rights based on contracts, those rights which come into play because I own those particular rights, and for invasion of those fundamental rights, I can go to the regular law court. For invasion of my fundamental rights, I have to go to the High Court or Supreme Court for grant of the writs of mandamus, writs of certiorari, writs of prohibition, quo warranto, as the case may be. So, in case of fundamental rights, the Constitution guarantees. In case of legal rights, contracts amongst the parties, they are the source, they are the starting point. For violation of the legal rights, the remedies approach the court of law against the tortfeasor or against the person who is at fault. In case of invasion of my fundamental rights by a government machinery, I can go to the apex court or I can go to the High Court for grant of the important writ remedy under Article 32 or under Article 226 of the Constitution. So with this, I have answered the question being put by the speaker on the aspect of how legal rights is distinguished from what's called as a fundamental right. And one more question put is difference between constitutional rights and legal rights. As I told, legal rights are a product of a contract which we make. I spoke of 5 important features of a legal right. I spoke, the first important point is person of inherence. Number 2, person of incidence. Number 3, content of right. Number 4, subject matter of right. Number 5, title of right. All these 5 features coexist to call it as a legal right. And in case of constitutional rights, the Constitution guarantees to the citizens, and that is the source is from a sacred document that is called as Magna Carta of India. So that is the difference between legal rights and what is called as constitutional rights. I think I made the 2 persons who had posed questions, I have clarified their doubts. If they still have doubt, they may even ask me. Yes.
Yes, sir. Just check in if we have any question on the Facebook, because out here there's no.
In fact, my talk here is in fact academic.
That's true.
And advocates, they can fine tune their, pleadings. I have used 18 different types of legal rights. You can choose, pick up the appropriate legal word, legal right at the appropriate place. As you all know, judgments which we write in the law courts, for a beginner, we just, as you all know, we cannot write very fine-tuned judgment. As we go on working, we have fine-tuned judgments. So, for a lawyer also, for a layman also, he just knows what's called as right, what's called as legal right. And by constant study of these 18 types of legal rights, we can use the correct legal word, legal right at the appropriate place. I told example of positive right, example of negative right. Example is, I am standing in front of a water pool or a swimming pool. I have right that nobody shall push me. I have got negative duty. I cannot push something else who is seeing the water in a swimming pool. So these concepts, these things, I can use in the body of the pleadings in case I am empowered. And this aspect of concepts in law, they are very, very basic. And the moment we pass out from law college, we don't read hardly, once again, the book called as Salmon's Book on Jurisprudence. My point is that is mother of all our legal literature. So the way you go back and read those books, we are reminded of our olden days with our law college teachers, and they are the important source for us to fine tune. Yes, sir.
So one Greece has asked, kindly mention book name once again. That's Solomon book.
I just read, my discourse is from Salmon's book on jurisprudence. Salmon's book on jurisprudence. There we got part 2. They are called as legal concepts. And
In fact, that book is always being given in the law schools that you should read this one.
Yes.
Whenever you are going.
That is the basic. And that book we read only for passing. And many of the law college students, they had tough time to pass this paper, jurisprudence. They could score well in CRPC or CPC, fine. But this paper they found to be very tough, because I have taught in law college also. And if they get pass marks 40, they are fine. If they get 40 marks, pass marks, they go to the temple in the evening, break not one coconut, 2 coconuts, because they just got past this paper. Jurisprudence. Don't mistake me. There may be some scholars who must have done research. I don't comment on them. But my point is, this particular subject we have read only in our law college days. Thereafter, we have hardly touched the book. My point is, advocates, all concerned, if we just go back to those books and once again read, we can fine-tune our pleadings, fine-tune our drafting. And the judge who reads those pleadings containing these important elements, he will have a firm mind that this counsel is a sharp person, sharp in law, sharp in legal acumen. Law for layman is different from law for an advocate or law for a person in the field. I tell in academy, I tell in the law colleges, law is for laymen, that is in a given words. But for judges, for advocates, they mean something else. And my point is, use appropriate legal words and physiology at the appropriate point of time to see that our talk or our pleadings will look very, very nice, and that the reader will feel that, yes, this is the case wherein the pleadings are very good, or that the speaker is having wide legal acumen. And that the next point is whether the legal rights affected the public policy or not. Affect the public policy in which cases? The question is whether the legal rights affected the public policy. As we all know, rights are confirmed by statute. Law of contract says you lend amount, then you get a agreement drafted, get it signed. So contracts empower the lender to recover the amount of dues from the borrower by means of a document called as loan agreement. So legal rights are created by the parties. I spoke of owner of right. He is called as owner. He is called as person of inheritance. He inherits. He gets. And I spoke of person of incidents. Person who is bound. So only a parties to contract are bound by the aspect of legal right. For breach by the borrower not repaying the amount of loan, the lender, owner of right, can move the court for recovery of the amount of loan. And we have seen law of limitation that states that recovery of amount of dues based on a promissory note, time limit is 3 years. If the law of limitation is amended by saying that after 12 years, you can recover the amount of dues, then public policy can be reflected by amendment to the law of limitation, by which the parliament may extend time by saying that henceforth, from this day onwards, recovery of amount of dues, the period of time is 12 years from date of availment of loan. So public policy, if reflected by means of amendment to the law of a given subject, they prevail. And as you all know, in case of legal rights, they are product of mainly contracts or agreements, and public policy and legal rights, they go hand in hand. If there is change in law, then change law is applicable to the particular contracts which emanate from and after the date of amendment, unless the amendment is retrospective from a given date. So with this, I have rather clarified the doubt of the speaker whether the legal rights affected the public policy or not affect the public policy in which cases. I think I have sufficiently clarified his important doubt. So with this, if you have some more doubts, you may kindly ask, and I am glad to answer.
No, sir. We had none. And thank you for the insightful session. And the year has become with a good note, 18 points to ponder about, whereas we have 12 months only in a year. So we have 1.5 thought processes. And as you rightly said, once you apply principally those issues, the drafting becomes better, and it looks like we say that synonyms or antonyms, if you use in the right perspective, it always gives every word connotes in a different way. Similarly, in the drafting, if we use a passive word and an active sentence, it expresses in a different way. The expression becomes totally different. So tomorrow, friends, we have the second session with the learned resource person, Mr. Vishwanath and Angadi, and the topic is concept of ownership and of person under law. Do stay connected with us at 5 p.m. Everyone stay safe, stay blessed, and once again, Happy New Year to all the participants who are watching us live on the Facebook, YouTube, and on this platform. And thank you, sir. We are delighted that the year has begun on a note which has given us a thought process. As you said, this jurisprudence is always given normally in the law college in the first semester. So we have started the year with the basic concepts of jurisprudence and moving forward. Thank you. Thank you once again.
I thank the organizers and also the viewers, because for me also, I could once again fine tune it in the morning. I teach it, but today morning I had to fine tune it, because as we all know, the thing is, unless we read once again, we cannot deliver properly. So thank you for giving me the opportunity to go back to the book, basic book, and I also was got a little more empowered. So with this, we'll meet tomorrow at 5 o'clock.
Yes.
And if you have got doubts on this chapter, the viewers viewing today, if they got any questions on this topic also, they may raise it tomorrow. Because tomorrow also will be on the screen. Tomorrow we'll meet at 5 o'clock. So thank you. Namaskar.
Sir.
Wish once
Namaskar,
again a very happy and prosperous new year. Namaste.
Thank you. Jai Hind. Namaskar.